Everybody's comfortable? Okay. Welcome to a discussion on preventing sexual harassment in the university community. Before I introduce our panelists, I do have some announcements. Number one, the President's Office is also a sponsor of this event, and that was inadvertently left off of the advertising. Number two, one of our panelists is ill, but we can cope, and I'll tell you how in a second. And number three, you are welcome to stay for refreshments following the discussion. Tonight we have two individuals who will be discussing the topic of sexual harassment as it pertains to the university community. On the far right, we have Jonathan Alger, who is a counsel from the American Association of University Professors. He advises college and university faculty on legal issues involving academic freedom and discrimination. And before his current post, he was a senior attorney at the Department of Education, the Office of Civil Rights, and there he worked on policies interpreting discrimination laws, applying to discrimination, including racial and sexual harassment. And on my immediate right, we have Hessie Harris. Ms. Harris is Associate Legal Counsel with the ISU Legal Services. She advises the Affirmative Action Office and the administration during discrimination investigations. She also prepares and submits university responses to discrimination complaints filed with external associations. And she provides legal assistance, guidance, and representation to the university administration on labor and employment matters. We suggest that the way that we will conduct our discussion this evening will be for each panelist to give a presentation, and Ms. Harris will be presenting both for herself and on behalf of Carla Espinoza, who's the Affirmative Action Officer and who is our missing panel member. When they are finished with their presentations, you are invited to direct questions to either of them specifically, or you can just throw out a question and we'll see what happens to it. So, Mr. Alger, if you'd like to begin, please.
Thanks, Denise. Can you all hear me okay? It's great to be here in Iowa, coming from Washington, D.C., where for the past year or so, we've been more or less consumed with the Lewinsky-Clinton scandal, and I thought, well, this is going to be a wonderful opportunity. I'm going to go out to the Midwest and talk about something in the heartland that will be of interest to folks there, and lo and behold, what is the topic? But sexual harassment. So it's not just an issue that's consuming the folks inside the Beltway, as we say, but is also an issue around the country. And I'm going to talk in my part of the presentation about sexual harassment in the academic context in particular, and going through the definitions from both a legal and sort of a political and social perspective. And then we'll be talking further about things like policies and procedures specific to Iowa State with Hessie Harris and her part of the presentation. And if you have questions at the end about things that we don't have a chance to get to, by all means, please feel free to bring those up. At AAUP, we're an organization, for those of you that aren't familiar with the American Association of University Professors. We work on model policies and procedures on issues in the academic context, on everything from academic freedom and tenure to harassment and discrimination to distance education, all of those types of issues that faculty members and universities care about. Sexual harassment has been a hot topic for us in recent years. We get a lot of calls, not just from faculty members, but also from administrators working on policies saying, can you give us some help in how to devise a good workable policy? And just recently, the magazine that we publish called Academe did a special issue on sexual harassment. I don't know how many of you have seen this. It has this picture of Adam and Eve on the cover. And this was the very first issue of Academe that was sold in bookstores. And we thought, well, this is an appropriate cover. We thought if we're ever going to sell a lot of copies, the title was Consenting Adults, Sex in the Academy. and there was a suggestion that we put them in brown paper wrappers, and maybe that would help sell a lot of copies. It didn't sell quite as well as the Star Report, but it did show us there was a lot of interest in this topic, and we've continued to get a lot of questions in the legal office on sexual harassment. And I'd suggest this is an especially appropriate time for universities to be looking at their policies and procedures, because it's not just the American populace that has taken an interest in this topic recently, but the Supreme Court has taken a renewed interest in this topic. For about a decade, the court had only taken 2 sexual harassment cases of any sort to address these issues at that highest level, leaving us to guess at what the standards ought to be and how the law ought to be interpreted in many ways. All of a sudden, last term, there were 4 cases that the Supreme Court decided to hear on sexual harassment. So there were 4 decisions from last year, and now there's another case pending on student harassment, and we expect a decision by the end of this term in June. So suddenly the Supreme Court is rewriting the law in large part on sexual harassment in light of our experiences over the last 10 or 15 years. And in light of that development, I think this is a very good time for people to look at university policies and to think about changes that might need to be made in light of these Supreme Court decisions. Well, let me talk a little bit about the definition of what sexual harassment really is and what's unique about the academic context. I'm sure most of you know that sexual harassment is considered to be a form of sex discrimination under the law, just as racial harassment, for example, is considered to be a form of race discrimination. And it's discrimination not just under Title VII of the Civil Rights Act, which applies to employment, but also under Title IX, which protects students. And students, as you may know, have the option of filing complaints with the Office for Civil Rights of the U.S. Department of Education, which is the office where I formerly worked. That office issued guidance in 1997 on sexual harassment of students, which has a lot of helpful detail. And if you need a copy of that, you can contact, well, I know Denise has one, and probably your Office of Legal Counsel does as well. Let me talk about some of the basics of what's in that policy guidance and the definition. First of all, sexual harassment does involve sexually related misconduct as opposed to things that are based on gender in a generic sense. That doesn't mean, though, that gender-related misconduct doesn't violate the law. You can have something called gender harassment or sex-based harassment, some people use that term, and that can be a separate type of violation of Title IX. A good example would be if a math professor said to his female students day after day, look, women are not as good at math as men, you shouldn't be pursuing this as a major or a field of study. That has nothing in terms of a sexual connotation necessarily, but it does have a gender-based stereotype, and that can be a violation of Title IX. So it's important to realize that just because something isn't strictly speaking sexual harassment, it can still constitute a violation of the law. Similarly, sexual orientation is an area that confuses a lot of people because they get it confused with sexual harassment. And harassment on the basis of sexual orientation does not violate federal law, although it violates lots of university policies and some state and local laws as well. But you can have harassment that is same-sex harassment. The Supreme Court did clarify that last year. There was a case involving an all-male workforce on an oil rig, and there was a male employee who was being harassed sexually by some of his colleagues. Now, one of the big problems when you have same-sex harassment is how do you prove that there's sort of different treatment on the basis of sex when there are no women there or there are no men in a workforce. So there are problems of proof in those cases, but it's important to know that you can have harassment, sexual harassment, if there's a male professor, for example, making sexual advances on a male student. That type of thing can constitute sexual harassment. But what we would call gay bashing, making fun of someone because of their orientation, that is not necessarily sexual harassment, but it would violate a policy on discrimination on the basis of sexual orientation. Finally, one other introductory point that has become increasingly important in light of the whole Monica Lewinsky scandal is this idea of unwelcomeness. Harassment under the law has to be unwelcome. And if you read the Office for Civil Rights guidance, they talk about the fact that with little kids, you don't expect them necessarily to come forward and say that something is unwelcome because they don't even know enough to do so. But when you're talking about college-age students, you do look at the age and the maturity level of students or employees. And so unwelcomeness becomes a more important standard when you have relationships which may or may not be consensual, or that perhaps started in a consensual way and then one or the other party decided they wanted out. If it weren't for this unwelcomeness portion of the test, the president's relationship with Monica Lewinsky probably would have been sexual harassment under most legal definitions. But as you've all heard Monica Lewinsky say, it was a consensual relationship from both sides. Now, there's obviously an issue of the power differential, and a lot of policies, including, I know you have been dealing with this at Iowa State, deal with the power differential and the danger of consensual relationships and the potential for exploitation. So that clearly is a separate problem, but the legal standard for sexual harassment does require unwelcomeness. It doesn't mean that someone has to have expressly said it was unwelcome. There are plenty of circumstances when it's pretty clear that conduct is unwelcome, but it is part of the test. Now, there are two basic types of sexual harassment which you've probably heard about in the news and from the cases. One is called quid pro quo. This is sort of the easy one to understand. This is when there's an implied contract or a threat to educational benefits or employment terms and conditions. Sleep with me and you'll get an A in my class. Or if you don't sleep with me, you will fail my class, or you won't get tenure. That kind of implied threat is quid pro quo harassment, and it requires some sort of power relationship. So the person who is the perpetrator has to have some sort of potential authority that they can exercise over the other party in order to constitute quid pro quo harassment. But the more interesting legal standard, and where a lot of the activity is right now in terms of litigation, is the hostile environment theory. And this is the theory that says that conduct that's sufficiently severe or pervasive or persistent so that it limits or interferes with educational benefits or terms and conditions of employment, if you've got that kind of behavior, and it violates what's called a reasonable person standard, so that from a so-called objective perspective, there's a limitation or an interference with terms and conditions of employment or with educational benefits, then you may have the creation of what's called a hostile environment on the basis of sex. This standard is important because it's sort of unique in the law when you think about the fact that the perpetrators could be anybody on campus. The hostile environment could be created by professors, by fellow students, by administrators, by combinations of all of those groups. So the perpetrators are potentially a much broader group than in other forms of discrimination. So that's important to remember with the hostile environment theory. And a reasonable person standard is obviously something a lot of people wonder about. Well, who is this hypothetical reasonable person? The reason it's so important is because the mere fact that someone is offended by behavior is not enough to constitute harassment. This becomes very important when you're talking about academic freedom and in the teaching and learning context. The mere fact that someone is offended by some class discussions does not mean necessarily that sexual harassment has occurred, and I'll talk a little more about that. There's been some case law about whether it should be reasonable person or reasonable woman standard if it's a female complainant. What you should know is the way that the Department of Education, for example, interprets the standard is that you have to look at the situation from the victim's shoes, so to speak. So whether or not you call it a reasonable woman standard or a reasonable man standard, if it's a male victim, you do have to put yourself into the shoes of someone in the same circumstances as the complainant. Let me talk about the most important part of the standard now, which is the harm that has to be shown. I mentioned you've got to show either a harm to terms and conditions of employment under Title VII or to educational benefits under Title IX, the statute that protects students. And what does this mean in the academic context? Well, in one of the decisions from last term, Justice Scalia wrote an interesting paragraph that addresses this issue, and I wanted to share this, a couple sentences with you. He says that Title VII does not reach genuine but innocuous differences in the ways men and women routinely interact with members of the same sex and of the opposite sex. So routine interaction is not covered. The prohibition of harassment on the basis of sex requires neither asexuality nor androgyny in the workplace. It forbids only behavior so objectively offensive as to alter the conditions of the victim's employment. Now here's the key sentence. Common sense and an appropriate sensitivity to social context will enable courts and juries to distinguish between simple teasing or roughhousing among members of the same sex and conduct which a reasonable person in the plaintiff's position would find severely hostile or abusive. That's it. That was our guidance on what sexual harassment is and is not from the Supreme Court. A lot of people were hoping the court would go a little further than that. But Justice Scalia gave us common sense and an appropriate sensitivity to social context. Well, the key issue for us in higher education is what that means. Common sense and the appropriate sensitivity to the social context of higher education. And one of the things that I focus on when I think about Title IX and students and how the law protects students, the educational benefits in higher education are very different than terms and conditions of employment that are protected at a factory or an office of some sort. The educational benefits in higher education include exposure to a robust exchange of ideas with a wide variety of teaching techniques, lots of different types of issues and examples in class, even exposure to ideas that some people might find offensive or controversial. And that's really important because if those are the benefits that are protected, then behavior which meets that standard does not necessarily constitute sexual harassment just because someone is offended by it. So let's talk for a minute about this idea of academic freedom and what it means, since this is at the heart of the work that the AAUP does in higher education, is to try to make sure that people understand this concept of academic freedom. The AAUP policy on this subject talks about sexual harassment as being not germane to the subject matter, that's an important part of the test. It also says that the academic setting is distinct from the workplace in that wide latitude is required for professional judgment in determining the appropriate content and presentation of academic material. Well, to quibble with our own definition for a minute, I would actually say the academic setting is a workplace for some people, for faculty and staff and administrators, not necessarily for students. But that doesn't mean that it's not special. It is different than any other workplace setting. And that's where the general policies from the Equal Employment Opportunity Commission, for example, don't necessarily work if you just stop there in the university setting. A lot of universities have done this for years. They took the EEOC definition of sexual harassment and they just put it into their policies and they thought that was it. Well, what does Justice Scalia remind us of? Remember that phrase about the appropriate sensitivity to the social context? Higher education is different than any other workplace setting precisely because of the nature of the benefits that are protected, this need for the robust exchange of ideas, for back and forth on a variety of issues, for a wide variety of teaching techniques. That's very different than what you would expect to put up with as an employee in a factory or an office someplace. The terms and conditions that are protected there are not necessarily to have ideas and controversial opinions expressed back and forth. Let me give you a couple of quick examples where this has come up in actual cases. There were a couple of English professors who have been charged with sexual harassment who've had their cases go to court in recent years under these typical EEOC definitions that talk about quid pro quo and hostile environment, but forgot to mention anything about academic freedom. They were both teaching writing courses, and one of them, Professor Cohen out in California at San Bernardino Valley College, liked to assign controversial topics to his students. He said, look, it's a writing class, it's required. They don't like to write about bland things. It's hard to get them interested in this course. So I like to assign controversial topics like pornography and get them to write opinion pieces about it. And he did this for years and years, and the university finally decided to come up with a sexual harassment policy. And when they finally did, after 17 years of teaching this way, Professor Cohen was the very first person who was charged with harassment. A student filed a complaint. Well, the court, went all the way up to the level just below the Supreme Court, the Ninth Circuit Court of Appeals, and that court held that the policy as applied to Professor Cohen was unduly vague, that it didn't recognize the specific context of higher education. And when you look at teaching techniques and the types of issues and examples someone might use in class, you need to have deference for the educators here. And this is why the concept of peer review in higher education is so important. It doesn't mean that anything goes. If someone gives sexually explicit examples in physics class day after day after day, that's probably not appropriate. There might be some occasion where it might make sense to do that, but certainly not day after day after day. But what about in classes in art history or sociology or gender studies or literature classes where you're studying novels that are sexually explicit? Well, there, the subject matter obviously lends itself to a certain amount of discussion, and there you want to know what do peers in the field think is appropriate here? Not what does some outside court or state legislature think, but what do educators think is the appropriate way to teach? And there's a lot of deference that the courts will show to this idea of your academic peers. So this concept of academic freedom is really important and unique to the higher education context and the definition. Since we are going to run out of time here quickly, I want to mention just a couple other things the Supreme Court did this last term that are kind of important to know about. When it comes to liability, there were a lot of questions about when a university is liable for sexual harassment, and some of these questions were actually answered by the court in the last term. The basic rule now is that if you have harassment that's committed by a supervisor, now this is in the employment context, if a supervisor has created a hostile environment or quid pro quo harassment, then the university is vicariously liable for that harassment if there's been any sort of tangible detriment. A tangible detriment would be not getting a particular promotion, not getting a pay raise, something tangible. Then the university is automatically liable in that context. If the harm is not tangible, and the law does not require the harm to be tangible, then the university can avoid liability if it shows that it had an effective anti-harassment policy and complaint procedures that were suitable to the circumstances, and that the person bringing the charge unreasonably failed to take advantage of those procedures. So what the court did is it gave a great premium to having good, widely disseminated policies and grievance procedures. And I think it also pointed out the prospect that you want to have multiple avenues of access, not just one person that you can go to file a complaint, but the opportunity to, especially at a big university, to have multiple points of access so that a procedure really is open and available to a wide variety of people. And you want to make sure that they know about it. The other part of the test on liability is, what about students? You heard this fairly high standard now that's being applied in the employment context. Well, the court actually made a significant distinction between students and employees. And it said a university again, we're translating from some other cases to the university context. But the rule is that a university is going to be liable for damages for sexual harassment of a student by a faculty member, for example, only if a high-level university official, someone who has authority to deal with the harassment, receives actual notice of the harassment and is deliberately indifferent to it. Now, everybody that doesn't study this kind of law closely wonder, well, why on earth would students get less protection than employees? And the technical reason has to do with the difference in how the statutes are drafted. I don't necessarily agree with the Supreme Court's reasoning, by the way, under Title IX here, where they gave less protection to students, because when you think about it, to show that the university had actual knowledge of the harassment and was deliberately indifferent is a pretty low threshold. But for practical purposes, I don't think that most universities are going to be content with this low threshold. For one thing, the Office for Civil Rights has sent a letter to universities around the country indicating that universities still will have responsibility for harassment of students, either quid pro quo or hostile environment, and students will be able to file complaints with the Office for Civil Rights. Furthermore, there's legislation that's already been introduced to make the standard for students the same as the standard for employees. So I think there's still further activity that we'll be seeing on this issue. Finally, the case this term is on peer harassment. This was not a topic that the Supreme Court addressed last year. They had a case of student-on-student harassment from the elementary and secondary school context. And it was very interesting. I went to the oral argument and had a chance to hear the justices. It was very clear there was a generation gap between the people who were bringing the case and some of the justices of the court. Scalia, among others, kept saying, well, boys will be boys. You know, they're focusing on teasing and playground events, and they can't understand how students could sexually harass other students in a way that a school would be responsible for. Interestingly, though, when it came time to giving some race-related examples, the lawyer could see she was getting nowhere when she was arguing about sexual harassment of little kids by other kids. So she gave some race-related examples, and then that got the court's attention. So we'll want to see what comes out of this particular decision, because by dealing with peer harassment, there could be a major decision on how you define harassment, and particularly the hostile environment theory in June. So a lot of universities are going to have to be looking at their policies as a result of this particular decision. With that, I think I'll turn things over to Hessie Harris to talk a little bit about some of the particular policies and procedures here at ISU, and then we'll have questions at the end.
Thank you, John. Can everyone hear me? Good. All right. Well, I'm going to start with saying two things. In my approximate 5 years here, it's been my experience that Iowa State University takes sexual harassment very seriously and is committed to dealing with it whenever it arises. That's first. Second thing I want to state is that while in my talk I may give some general fact examples, can you hear me now? Some general fact examples from my experiences here, as well as from court cases, I cannot and I will not discuss the particulars of specific cases that are current or past. University cases I'm speaking of now. As was said, Ms. Espinoza can't be here tonight. She's got the bug that I think we've all been passing around for about 6 weeks. You can see I've still got part of it, but as I explained to her, the difference is I cough intermittently. She's constantly doing it, and also I can recognize my voice, and I couldn't recognize hers when I was talking with her. At any rate, I promised Carla that I would address. There were two topics she wanted me to address. About the law. Iowa State's policy. Carla asked me to speak about two things. She wanted me to talk also about the assistance program, which is a part of the sexual harassment policy. Carla can't be here tonight, but the Associate Director of Affirmative Action is here, and I'm going to ask her to stand up, and she's going to tell reviews and investigates sexual harassment complaints that we hire out when we bring in an outside investigator. Records on sexual harassment. Is there anything I left out, my dear? Okay. It's a unique feature of our policy. I don't know how many universities do have it. I think we may be the only one. The assistants are people who are trained, who are in various areas of the university, departments and what have you. They are named by the DEOs. They help. They do not do investigations, but they are a resource for complainants, for people who just need information. They have a very, very important supportive role. A person who feels they've been harassed can come in and talk to them. That person can go with them when they're ready to file a complaint. If they want to go through the informal resolution process, which we will talk about, the person can go with them. We had one case here on campus, sexual harassment. The assistant was invaluable in that not only did she encourage the complainant to finally file a complaint, the person was having some psychological problems because of the sexual harassment, and the assistant directed her and encouraged her to go into counseling. She's fine now. And for anyone who doesn't think that that's a very important role, I'll tell you something from my own experience. One of my classmates in law school was Diane Williams, who was the plaintiff in the case of Williams versus Saxby, which you probably don't know anything about. That's the case that made sexual harassment cognizable under Title VII. In other words, it's what made it illegal. That's when it became considered sexual discrimination, as Jonathan was mentioning. Diane told me that the hardest thing with her case was that she had no support at all. She had a supportive family. And her attorney, Michael Hosfeld, who's well known in Washington, D.C. today, was fresh out of law school, but he believed her. He was supportive. It took 12 years for them to win that. When they began, Michael's wife was pregnant with their first child. When they finished, Michael had 3 kids. But the point is, here again, there was no assister program, there was no affirmative action office she could go to. It was just fighting it on her own. They took on the Justice Department, they won. Okay, the other thing, let's talk about the complaint process here at Iowa State. There are a number of ways to approach it. There's the informal process that can be used. Under this process, if a person has a complaint, they will go to the administrator who supervises the person against whom they're making the complaint. That administrator is going to review the matter, and he's going to examine the various options for trying to resolve it. That may mean something like meeting with the alleged harasser and then meeting with the complainant. It may mean meeting with the two of them together. He will look at the problem and try to work it out. One example I can give you, we talked about academic freedom. We had a case here where a professor made a sexist joke as a part of his lecture. It was woven in. It wasn't necessary. The students went to the DEO, and the DEO approached the professor. We're talking separate meetings here. And after discussion, the professor acknowledged, yes, this was inappropriate. He took that joke out of the lecture. He also revised the lecture. The matter was settled. They never met. Sometimes there may be a mediation, so to speak. But what has to be understood is a confusion at Iowa State. That type of informal resolution where the parties sit down, these matters are complainant driven. I've had instances when the alleged harasser will say, well, we have a right to meet. This person may not want to meet with you, and we're not going to force them to do it. So it's if the victim, so to speak, the complainant wants to approach it that way, that's fine. But it doesn't mean, this is not mandatory. The other route is the formal complaint. And the formal complaint would go to the affirmative action officer. You might be meeting with Abby. The formal complaint must be in writing. And there's specific procedures as to what it should contain. And the affirmative action officer will go through that with you. We have a limited amount of time here, so I'm not going to go through all that. Once the complaint's filed, if it's determined it warrants, well, it'll be reviewed and investigated. And at that point, either Evie will undertake it, or as I said, we may have someone do an outside investigation. The investigation is done, we're going to get a report. Now, at that point, if we found harassment, the report's going to go to the DEO. And if that person accepts the report, then the report and recommendations, there may be disciplinary action. But you need to understand something. This is an investigation. Now, we have to understand there are two people in this. The alleged harasser and the victim. Both parties have rights. At this point, once we've got this report, if it's decided it's going to be disciplinary action, we've got some due process considerations here. There's various appeals, depending upon the classification, if it's a professor, we have one, as faculty, we have one set of procedures. If we're talking about PNS, we're talking about another set of procedures. Merit supervisors, another set. If we're talking people in the collective bargaining, the merit employees, that's a different set of procedures. So the reason I'm focusing on this is that sometimes people who they feel they've been victimized and there's been an investigation, why don't you do something to him or her? We're going to. We've got to follow the proper procedure here. And these procedures sometimes do take time. But as I said, these procedures they're designed to get to afford protection to both parties. Now, once we've got the procedures have been implemented, if in fact, let me back up a bit here. Let's say that there's been the investigation and the affirmative action officer didn't find sexual harassment. Every accusation doesn't necessarily have merit. Let's say there's no finding. That complainant can appeal to the president. If the president reviews it, I think it's about 5 days. If the president reviews it and the complainant is still not satisfied, you can go to the Board of Regents. The Board of Regents is a final internal appeal. And one thing is not quite clear in the policy, and I want to explain this. The policy says that's the last internal appeal and that the complainant can go to an outside agency at that point. It's their discretion. Then it also talks about the fact at the end that a person can go to an outside agency. What's not clear here is that a person does not have to exhaust the internal procedure in the university before they go to the Iowa Civil Rights Commission or to the EEOC or for the Office of Civil Rights. Many times, as was indicated, I get complaints where people have gone there first. So that's why I want to make that clear. Okay, now, excuse me. Final means of bringing this to the fore is direct institutional action. Here again, you need to read the policy, but there is provision for any administrator who becomes aware of an issue that needs to be done. If it's under their jurisdiction, they've got to deal with it. If it's someone else's jurisdiction, they've got to make sure the information gets to someone so it does get dealt with. But basically, when we're on notice, we have to act. One thing I would like to say about the assisters, just forgot that, is that if any of you are interested, they're on the AAO webpage. You can go there and you can get their names if you need one. As I said, they're trained. There's a new training coming up. If anybody's interested in the program, you can talk to Effie. Okay, and what I'd like to do now is talk to you more about the policy itself. The policy's goal is to prevent the behavior and to stop it once it's occurred. So the ISU's policy is a little bit broader than the law. You need to understand that. It goes beyond the legal definition of sexual harassment. It covers activities which may not fit the legal definition, but they may still be improper for the workplace. One example I'm going to give you now, about 2 years ago, there were 3 employees who were accessing pornographic sites on computers in a common area, semi-public, so to speak. There weren't any female employees in this unit, and no male complained. So they were disciplined for inappropriate behavior because this wasn't sexual harassment. We didn't have a victim, but we did have inappropriate behavior in the workplace that fit within the definition. So, now I want to talk to you more about some of the other things that violate the policy. I'm going to be speaking with you from the policy. And as John said, quid pro quo is pretty clear. A little this for that. It's very clear what you're talking about there. Higher grade, higher salary, what have you. Hostile environment is where things sometimes get a little fuzzy. Many times, sexual harassment, people don't know that they're harassing people. And we're talking about a social change. There are things today that where sexual harassment is recognized, was before it was considered legitimate courtship. Persistent behavior today. This person, and it wasn't that it wasn't harassment 20 years ago, it wasn't recognized as harassment 20 years ago. That's the difference. Displaying pictures, now one would think that people are aware of that, but there's a recent case out of the Iowa Supreme Court where the plaintiff alleged that if she worked in a dough factory, the men were shaping dough into the shape of the male sex organ and hanging it on their belts. She's the only woman in the area. Now what happens is people say, well, am I going to be, one of the things that's mentioned here is, as an example of inappropriate conduct, brushing up against somebody. I get the question, am I going to be charged with sexual harassment if I accidentally bump up against somebody? No, but if you do it 5 times in 5 days, every time you pass me the copier, we got a problem. I mean, as he said, there's an issue of common sense here. One of the things that's mentioned here is unwelcome sexual flirtation. And the question is, can I not say compliment someone? I think of an example from my own history. Years ago, a person told me that asked me to call me on the phone and said that they really liked the dress that I had worn a couple of days ago. I said, well, thank you very much. And then it was several years because I really like that braless style. Now see, if he stopped with the compliment, we'd have been fine. Now, where are we going? One of the things that often happens is he talks about the blue-collar situation. You have, and we have had that issue arise here, we have people who do engage in sexual banter. And then a person makes a complaint. Well, the first thing the co-worker will say, he or she was just as involved. But once that person is told, hey, this offends me, it has to stop. And I'm going into these things because these are the things where people, it's almost where people get caught, so to speak, where the problems arise. Those extremes, we know about those. One of the things that is mentioned here is the sexually oriented kidding, teasing, joking, or flirting. What I would ask you to think about, and a lot of gray hair here, including mine, let's go back a few years. There was a time when ethnic and racial stereotypical jokes were considered fun. Even quote unquote Caucasian liberals would make those type of jokes in front of blacks, Hispanics, Chinese, and expect them to laugh because it was supposed to be funny. Well, this is the same type of thing, and finally it's recognized it's not, because it's the old one-upsmanship here. You're not in an equal position. It's the same thing with this sexually oriented joke. It's not funny because it's coming from the person who has the power. And one of the things that I want to talk about in terms of power, we're not just talking about the issue of who has more power this way. Remember something, especially if you're talking about a staff situation. If you get one woman in a setting with all men, they may all be making the same salary. Who's got the power? Reverse it. Who's got the power? You have the power of the peer.